Hey guys, so you ready for it? Today's January 16, 2023, 5:51 p.m. Central Time. I'll start off with this. This court case that will be getting heard oral arguments tomorrow, January 17th, 2023, by SCOTUS, Supreme Court of the United States, is, in my opinion, going to be one of the most dramatic outcomes in our immigration litigation that will happen in my lifetime. Why it's not being reported on anywhere as being such, in my opinion, is shocking. I have only seen an article in a news network by Fox News saying that this exists, that this is happening tomorrow. And the article was trash as far as explaining what the situation was. So I went further in depth with it, and so far in depth that I actually listened because they don't have videos, the argument at the Fifth Circuit to understand this case, because even the website I'm using, which is SCOTUS blog, okay, and regardless of how they lean, they cover cases really well, which I'm going to show you, and I'm going to explain how this all is coming down. It does in that article, if you will, on SCOTUS blog, it does not show what this really hinged on. This illegal transgenders case, no joke, hinged on the word probably. I am not kidding. When I watched the Fifth Circuit, that's where that probably term came from, and I'll totally explain it. Otherwise, it doesn't explain it at all in the SCOTUS blog. It doesn't explain it anywhere, period. So you have to watch listen to the Fifth Circuit's arguments to understand how ridiculous this case truly is. This case, when I say ridiculous, meaning it never should have reached the Supreme Court by any means. This is, as far as I'm concerned, a cut and dry court case that never should have been taken up by SCOTUS. This should have been one of the things that went to one of the justices, and the justices denied and deferred back to the appeals court. Hearing this will either do one of two things. It will flood our judicial system, our appeals courts, with illegals trashing our appeals courts, time, effort, everything, for anything else. Or it will keep intact the current immigration litigation system we have. That's a big deal when you have millions of people entering this country in 2 years under this president. Obviously, illegals come in all year long for years, right? I'm not ignorant to that fact. But that's why this is so big now. As far as I'm concerned, this case is so big now, is because of the amount of people that this will affect who will be going through immigration litigation if they have the ability to go to our judicial system bypassing the immigration litigation. Can you imagine what flood that would be? I mean, our immigration litigation system is backlogged. Everybody knows that. We don't have enough judges. We don't have all this, blah, blah. Imagine that backlog, that complaint, now moving on to the federal level in the circuits, okay? Big deal, isn't it? That's a big goddamn deal. So when you come across this wonderful border of ours, there's a process that you go through, and this is very simplistic, and then I'll get into the case. You go before an immigration judge. They determine, what you are going for, if you're going for asylum, why you're going for asylum, all these wonderful things. This particular person went before an immigration judge for two portions of saying that they were able to stay here because of, here, I'll just get into actual legal terms real quick, for two reasons. One, withholding of removal under the Immigration Nationality Act. Basically saying that, where is it? Hang on one second. I don't want to be wrong with this. Saying that if she was deported back to Guatemala, that her life would be in danger and all this stuff, and she wouldn't be safe. Okay? And then she also said she applied for protection under the Convention Against Torture Act, an international treaty, which is actually quite a stretch. And that actually has to do with being tortured with government's consent. Okay? So she's basically saying if she goes back to Guatemala, the Guatemalan government, which, by the way, allows you to change your gender, okay, for one, has no history of going against the LGBTQ plus whatever the fuck community in any way, as far as like throwing them off buildings, putting them in jail, any situation like that. The Guatemalan government has no history of that. So that Convention Against Torture portion of this case is so ridiculous that it was like such a stretch. So obviously those were the two things. So if she was deported back to Guatemala, two things: she would be persecuted, okay, and harmed and all that stuff because of being LGBTQ, and two, she would also be harmed, tortured, whatever, under government's consent. Okay, that was her argument before the immigration judge. The immigration judge heard her case and I'll tell you what they found, but basically said, no, you have no merits for this. Okay. You're getting deported. So deportation papers were given. After that, the review of the immigration judge falls upon the Board of Immigration Appeals. Okay. The Board of Immigration Appeals reviews the judge's, whether not necessarily deportation, because the judge could come to a different conclusion, saying that, oh, you do fall under that. I'm just saying in this particular case, the deportation. So whatever the judge determines, the Board of Immigration Appeals reviews it. And then they determine whether they agree with it or not. Okay? And in this case, the Board of Immigration Appeals did agree with the judge. Now, this is where the term probably comes in, because fact-finding can only happen under the immigration judge portion. Meaning, like I'm trying to explain this in a different way. When you find facts for a case, just like, if you kill someone or whatever and you're going before a court case, there's a way that you bring up discovery, right? Well, the discovery has to happen and the fact-finding has to happen under the immigration judge, okay? So anything that doesn't or isn't found at that point cannot be taken into consideration by the Board of Immigration Appeals. And that's what happened. Follow me. The Board of Immigration Appeals, this is what they came back with. Let's see. Okay, it says, on review, Board of Immigration Appeals ultimately affirmed the judge's decision. The BIA, which is that, rejected the judge's conclusion that Santos had not been subject to past persecution as part of the LGBTQ community, holding instead that she was entitled to presumption of future persecution. However, the board also found the government had successfully rebutted this presumption, and several cited reasons for doing so, included Santos' rape took place. Okay, this person was raped at 12 or 13. Okay, and that's her basis. I'll go up to here real quick because this was her argument. Okay, the case arose from the government's attempt to deport Leon Santos, a 34-year-old transgender woman, a citizen of Guatemala. Santos left home at age 13 or 14, after which she lived in Mexico for several years. She also unlawfully entered the United States at least twice, leading to her deportation to Guatemala in 2008 and 2012. Despite these prior deportations, Santos returned to the United States in May of 2018. She was detained and subsequently applied for a type of humanitarian relief known as withholding of removal. under the Immigration Nationality Act. She also applied for protection under the Convention Against Torture Act as an international treaty. So the withholding of removal portion of the Immigration Nationality Act, that's the part where if she goes back, she will be not like, basically people will berate her, she'll have problems, her life will be in danger, all this stuff. The Convention Against Torture has to do with the government danger, okay, that part. So that was this case originally. So let me go back here. So the reason the Board of Immigration Appeals, BIA, said the government had successfully rebutted this presumption that this was not going to happen, okay, that she wasn't going to have a problem going back. It cited several reasons for doing so, including Santos' rape took place a long time ago. She did not report it or know her attacker's whereabouts. She had voluntarily returned to Guatemala several times without harm, and she recognized that there might be places in Guatemala to which she might be safely relocated. That's where this article explains nothing, okay? That last part that I have highlighted, she recognizes there may be places in Guatemala to which she might safely relocate. That was something that was brought up when she, let me go back to here, when she had finished the judge portion, went to the Board of Immigration Appeals, and they interviewed her, okay, to review the judge's case and see whether they agreed or not. They interviewed her, and one of the questions was, if you didn't return to blah, blah, blah city in Guatemala, is there another city that you could go to where you would feel safe? Her answer was probably. That's what was found as fact-finding discoverability under the Board of Immigration Appeals. So that can't be, I know that sounds ridiculous, right? It sounds absolutely ridiculous that portion probably wasn't done under the judge. The judge didn't ask that question. The judge never reached that question. So that can't be part of their review. And the bigger portion of this is the Board of Immigration Appeals. Literally, there's a law within DHS that fact-finding cannot happen. Okay, so it's not just an opinion. Fact-finding cannot happen, or discovery, if you will, under the Board of Immigration Appeals. Since that happened, and they came out saying what they did, with simply saying she recognized there might be places in Guatemala to which she might safely relocate, she had a hissy fit, okay? And decided at that point to bypass going back to the judge and saying that the Board of Immigration Appeals used fact-finding information they weren't allowed to use to review my case, which needs to be litigated in front of an immigration judge. There's a process for that. I'll go into that in a minute, which is what this whole case hinges on. Once you've exhausted all administrative remedies, okay, you've gone back to the judge, rules on whatever it is, it goes back to the BIA, and you can go back and forth with the BIA a shitload. I mean, like a ton. And there's a statute that requires non-citizens to exhaust all administrative remedies before going to the Federal Court of Appeals, our judicial branch, our federal judicial branch, right? That's what keeps illegals out of our federal court appeals process all day long. Obviously, they do go to the Federal Court of Appeals in certain circumstances in which they've exhausted shit. But that's a bit like exhausting something between this situation right here, the judge and the Board of Immigration Appeals, can take years. Absolutely years. It's crazy. So rather than go back to that judge, she appealed to the Fifth Circuit about that discovery issue and tried to blow up her case and say they couldn't do that. They have to throw that out. I'm able to stay here because of that kind of thing. And the Fifth Circuit agreed with what was found to be done by the judge. They did agree that the Board of Immigration Appeals did do fact finding, and that is a problem. Okay, and that's where this case court comes in, and that's why it came to SCOTUS. But that didn't change her deportation. Okay, so they obviously went to SCOTUS. Again, this court case outcome does not even affect this person's deportation case. So with that being said, okay, the probably is what caused all this. So the court case itself, and they say it really good in the very beginning. In a nutshell, it asks whether non-citizens must petition the Board of Immigration Appeals to reconsider its allegation errors, which was the fact-finding issue I explained, which is not explained here, before seeking review to a federal courts of appeals. This question has split courts, and the Supreme Court's answer could significantly impact non-citizens facing deportation and the immigration courts tasked with hearing their pleas for relief, which is exactly what I said. If they determine that they can bypass and not have to go back and forth with the judge in the immigration appeals and go into our justice system, all hell will break loose, right? So this is the terminology that this hinges on. Here it is. The parties now present to the Supreme Court the two questions relating to the Fifth Circuit, which, by the way, I listened to this Fifth Circuit on YouTube on the U.S. Court of Appeals for the Fifth Circuit. They have a YouTube channel. A whole 83 people watched this case. It was posted April 28, 2021. And what's interesting is the fact that 83 people watched this. And this could change our immigration litigation system now. So like I said, this is a big deal. So anyway, that's where I found it. I'll give you the link. And you'll understand the probably word that came up and what caused this. Anyway, so it says the parties now present Supreme Court with two questions relating to the Fifth Circuit's interpretation of the INA's section 1252 DI, which I'm just going to say section from this point forward because it just refers it over and over again. The first is whether this statutory exhaustion requirement, which is literally, let me actually cite it because they do cite it up here somewhere. Okay. The what that statute says is that the states of the federal appellate court, quote, may review a final order of removal only if the non-citizen has exhausted all administrative remedies available to the non-citizen as of right, which is what I was talking about here. That's when they can go to the Court of Appeals. Okay, so let's go back down. Okay, so they're determining whether the statutory exhaustion requirement is either jurisdictional or procedural. So if it's jurisdictional, then the courts can, okay, let me try and do this in a different way. If they determine it's jurisdictional, then that non-citizen has to go through our current immigration litigation system. If the Supreme Court rules that that statute is procedural, basically meaning that it's not required, that means that non-citizens, once they get their deportation stuff and go through the Immigration Board of Appeals and get rejected, they can now appeal to our federal system and go into our federal courts. So we want, as far as I'm concerned, as a United States citizen, the Supreme Court to rule on the jurisdictional portion of this so everybody stays in the immigration system versus the procedural, okay? That's what this case is about. 8 circuits took this matter up. 1st, 3rd, 4th, 5th, 6th, 9th, 10th, 11th. All deemed it being jurisdictional. Now, there's two courts, a whole two courts, second and, of course, the seventh, disagreed. And when I say, of course, the Seventh Circuit is ridiculous. They come up with the most liberal bullshit that makes no sense. I don't care if you've listened to this entire video and you are a liberal. I don't care. Look at the Seventh Circuit's court cases and tell me that it is not a extreme court judges that are activist judges. Prove it wrong. Prove me wrong. Prove me wrong. Anyway, they disagreed. They said that the failure to exhaust discrete issues is merely a procedural defect that leaves their subject matter jurisdiction intact, which means exactly what I said. They don't have to go back, and discrete issues don't have to go back to the judge, and they have to go back and forth in the immigration system. They can bring it up to the federal courts, okay? That's what this hinges on, because of the word probably. And the government actually, as far as I'm concerned, did a really good job of arguing at the Fifth Circuit. But when that probably term popped up, and I don't even think that was intentional, if you listen to the orals, probably he brought up a section in which the Board of Immigration Appeals DHS was interviewing her and used the term probably about her relocating to some place that is safe. And she said, probably. That's what he brought up and said stuff. And that's where the discovery happened. And that's like why I say this is about probably, because that's what the discovery was, that the fact finding that should never have happened because the judge didn't even consider that or anything. So that's what this was all about. That's what this is all about. And Santos said, let's see, the exhaustion requirement obligating Santos to submit her impermissible fact-finding allegation to the BIA in a motion to reconsider before the Fifth Circuit. She argues it did not. So in other words, she argues she didn't have to go through the exhaustion process. She said even if that section is jurisdictional rather than procedural, she believes that the motion to reconsider is discretionary and therefore does not court as the administrative remedy available to her as, quote, as of right. As of right is part of the statute, okay? So she's saying you don't have to do it. It's just suggested. Okay, that's what they're saying, that statute suggesting it. And that's truly not the case. And the way that they're arguing back and forth, the jurisdictional versus procedural, has to do with the term review versus, let me see here, let me get it right. Review versus jurisdiction. So it says here, the government counters the section clearly restricts the Court of Appeals' power to hear issues not exhausted in the BIA deportation proceedings. In particular, the government points out that Congress need not use the term jurisdictional to limit the cases to the federal courts may hear. Instead, it points to the provisions that which the Supreme Court has found the word review as imposing a jurisdictional limit. So it says the section speaks directly to the appellate courts, instructing them to review a BIA final removal order only if the non-citizen has exhausted her administrative remedies. She's saying no. She's saying no. That section is totally discretionary. I don't have to exhaust myself in this court to do anything. I can bring my case up to the Federal Court of Appeals and get into our judicial branch and whine there instead. So this court case is a big deal. So it hinges on the two words, jurisdiction and procedural. Whether that statute is jurisdictional or procedural will determine this. And it all came from the word probably. Hopefully that made sense. So I'm thinking after this is heard, oral arguments, it could possibly, hope so, kind of catch traction in the news, okay? Because this is a big deal. This will absolutely change our immigration litigation system. Like, big time. It's so disturbing that this case made it to SCOTUS based on basically nothing, okay? And it's not even going to change this illegal transgender's deportation papers, okay? So this bitch is going back to Guatemala regardless of the outcome of this case. This is Are You Ready For It? Take care, guys. Have a great night.